Right, my friends, I just pressed the Let's Go Live button, and so we've got to wait for the stream to connect itself all across the fruited plain of America. Unfortunately, we are having some Rumble connection issues. We've been having some Rumble problems for the past couple days. We're trying to get our videos uploaded. Looks like we got a couple of them being uploaded, but we are not live on Rumble. I tried to schedule our live twice today on the Rumble feed, and so our Rumble friends will miss you, but we'll be posting the videos as soon as we can. I think it's a more widespread problem than just us. So we'll be, of course, getting that situated as soon as we can. We've got YouTube, Telegram, and locals are alive and well, and so that is tremendous news. That means that we can go ahead and get started. So let's do it, shall we? Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live, the show that spotlights misconduct involving police, prosecutors, and politicians. My name is Robert Gouveia. I am a criminal defense attorney, and today we're talking about that illegitimate counsel, spurious counsel, certless counsel, Jack Smith, who is now trying to get certain evidence about January 6th precluded from the January 6th case. Isn't that fun? So he's prosecuting Trump, but he doesn't want Trump to use any defenses that he thinks are problematic. And so he submitted a motion in limine. And the motion in limine will be a lot of fun to unpack, because this is where he is attempting to get Trump's defenses excluded from trial. And that's not good. And so we're going to go through that. Now, the case is on appeal, and so he's not supposed to be filing anything at all, and he is. Donald Trump responded to this statement. You can see today, December 27th, calling Joe Biden's errand boy, deranged Jack Smith, what he is. And so we'll go through that all in the first segment, as you can see. Then, in the second segment, Donald Trump victorious in Michigan. And we'll go through this ruling. We know that in Colorado, the Supreme Court there has said Trump is not on the ballot pending appeal. And so it's kind of this, a little bit of a stay, not a little bit, there's a stay on that case. And so Colorado is one. We talked about other states, but Michigan is now saying Trump is staying on the ballot. So not going to be kicking him off. It is actually an interesting order. There's a dissent in there that's actually a little bit longer than the order. And so we'll read through that in the second segment. We'll also follow up on that story from yesterday, where they said that in Colorado, the judges are under attack. Those judges who wrecked Colorado's right to vote for Donald Trump, they were freaked out. We covered a whole segment on this yesterday saying they're under attack over there. Well, it turns out there weren't any specific attacks that were really being bandied about. And so we'll see what CNN said about that. And then we'll also learn that the person behind a lot of these efforts, in particular the effort in Colorado, is George Soros from the Open Society Foundation, because one of the biggest donors to crew the Coloradans to remove Trump, they are admitting this, right? So this woman says, yeah, that's him. George Soros is the person behind a lot of this. And then we'll turn our attention over in our last segment to what's happening in Congress. Big questions about whether Joe Biden colluded with Hunter Biden to snub Congress. Kind of a criminal conspiracy might have been afoot between the White House, Joe, and Hunter. Joe runs the DOJ. Hunter was showing up to snub Congress and defy a lawful subpoena. And we know that Karine had already told us that Joe was familiar with Hunter's plan. So now Congress is sending a letter over to the White House. They're saying, hey, are you guys colluding with Hunty Poo to try to avoid justice, to defy congressional subpoenas? And that itself might be an impeachable offense. And so we'll go into all of that and see what's happening there, and then listen to Comer as he reacts here for a bit and helps unpack what is happening there. So we've got a lot to get to, as you can see, my friends. And so if you want to be a part of the program, the best way to do that is by joining us, subscribing to this channel. Great thing to do. We also have our members only community, watchingthewatchers.locals.com. We had a great members only stream this morning. We do Saturday streams. We do members only after parties. And so come and check us out. Watchingthewatchers.locals.com is a good place to come and join us. We also have our website. Shop is now available. So if you want to support the show, a great way to do that, grab a shirt, grab a cap. I wear mine every day, and it has the Watcher symbol on there. And the Watcher symbol is something that's much deeper than just a hat. Okay, it is justitia. It is libertas. It is cutting through the bonds of ignorance. It is identifying each other through the shields and defending our lives and our communities and our families and the people that we love. It's all baked into this. And so it's a great way to support the show. You can also get flip-flopping Joe Biden, flip-flopping Hillary Clinton sandals. Those were a big hit at Christmas this holiday for our family. And so also ungovernable shirts and other things. We'd also love it if you checked out and signed up for our daily newsletter. You can just click here for instant access and get all the show reports delivered right to your inbox on our website. There's also reports here. So if you want to read any of the PDF files, they're all here. Okay, we try to chronicle all this stuff so it's easy to share and so that it's archived for all the generations to see. So robertgovea.com is the place to go check all that out. Thanks for checking out our website. We put a lot of work into it, and we hope you enjoy it. So without any further ado, let's get right into the meat and potatoes. Jack Smith filed a motion to preclude Donald Trump's evidence in the January 6th case. For some reason, Jack Smith doesn't want Trump to be able to defend the January 6th attack, they call it, with his own evidence in the January 6th case. It's kind of a topsy-turvy world, but that's what this clown show of a prosecution is. And what we're going to be looking at today is what's called a motion in limine. It's a preliminary motion. Remember, when we're in the middle of trial, we don't want surprises. The stuff you see in Hollywood is kind of fictional, that here's the gun, and they pull it. No, it's not really how it works. We want everything to be nice and tidy and orderly before trial starts. And so Jack Smith is filing his motions right now saying that trial is going to be starting in March. And we're all sitting here scratching our heads saying that's strange because the case is on appeal. And while it's on appeal, this court doesn't have jurisdiction over this type of stuff. And so from our perspective, Donald Trump and his defense team are just sitting there when these filings come in, and they're not even looking at it. Like realistically, there's what they're doing publicly. We're not looking at it. We're on appeal. We can't play in two stadiums at the same time. We can't be in Judge Chutkan's courtroom and the Court of Appeals simultaneously. And we're currently in the Court of Appeals. So we're not even paying any attention to what you're doing, Jack. But Jack is so petrified that he's going to lose out on this opportunity to get a conviction before the elections and not have his trial go, either one of them, this one or the classified documents case in Florida. And so he is acting as though the case is just on schedule, and he's filing motions, and Donald Trump is very unhappy about it. You can see his campaign already issued a response to this, saying this guy is out of control. He is. He's absolutely outside of the confines of what I would say is courteous practice, definitely, but maybe even illegal filings if you were to be aggressive with it. So let's go through the motion in limine. This is from Jack Smith. This is supposed to not be filed right now, according to my interpretation of this case being on pause. But Jack Smith doesn't care. And he's filing this in Judge Chutkan's courtroom, and we know she doesn't care. And so as soon as this case comes back down, when it does, Jack Smith is going to say, oh, perfect, we're ready for trial tomorrow because we've already been doing our work. But Trump's going to say, no, we're not ready because we stopped working on this back in mid-December when this case was accepted for appeal. And so then Chutkan's going to say, well, you should have been doing a bunch of work, and so you should go fast, and let's get this trial back on track. And this is why they're going to try to push this in March. We'll see. Now, Jack Smith submits this. It's the government's motion in limine, and it is submitted in Chutkan's courtroom. You can see it is the United States of America versus Donald Trump. This is Jack Smith and his deranged thugs there at the DOJ writing. They say, hey, dear Judge Chutkan, through public statements and filings and argument and hearings before the court, Donald Trump has attempted to inject into this case partisan political attacks and irrelevant and prejudicial issues that have no place in a jury trial. Trump is beneath the dignity of your courtroom, Chutkan. Now, although the court can recognize these efforts for what they are and just disregard them, the jury, the DC Democrats, if subjected to them, may not. And so this court, says Jack Smith, should not permit Donald Trump to turn the courtroom into a forum in which he propagates irrelevant disinformation. And Chutkan should reject Trump's attempt to inject politics into this proceeding. Because, of course, this is not a political prosecution. Give me a break. This whole case is political, which is why they're trying to prosecute him and get the trial on schedule for March 4th, the day before Super Tuesday. Because Jack Smith knows that if he can't get it done there, it's going to be continued into the heart of election season after literally Super Tuesday. And they may not get it done before November. So they're petrified, which is why Jack Smith also tried to leapfrog the Court of Appeals and go to the Supreme Court. Because we need to go very fast. Why, Jack? You didn't explain your urgency and your motions, so why do you need to go so quickly? Because of the election. It's not justice. Now, to ensure that the jury remains focused, says Jack, on its fact-finding duty and applies the law as instructed by the court, they say Trump's improper evidence, do you see that word? Isn't that a fun word? An argument should be excluded. So, in other words, it's evidence that is bad for Jack, who's illegitimate. Now, they tell us, look at this little footnote here, footnote 1. See how that is right there on the title? It says here, the court has determined, Judge Chutkan, that the deadlines in the pretrial order are, quote, held in abeyance, whatever the heck that means. While Donald Trump's appeal of the denial of certain of his motions to dismiss are pending, right? So I read that as this is done. So Donald Trump's team, in my read of it, they don't have to read this or even look at it. But of course they will. But the point is to make a point, saying, we are not in your courtroom, dang it. Stop filing paperwork that we can't read right now. Nonetheless, says Jack Smith, even though you ordered us to be held in abeyance, nonetheless, we don't care to provide the court and Donald Trump with notice and to promote the prompt resumption, right? That's what they really want right there, of the pretrial schedule if and when the mandate returns. The government will continue to meet its own deadlines as previously determined by the court. Okay, so the government is like playing like this fictional role-playing game. Like, well, we don't know what you're doing, Judge, but we're still going to trial. She's like, yeah, but it's my courtroom and I'm the judge. Like, well, we'll see you in March for trial. She's like, hello. So they're just going to keep going. The judge has ordered it held in abeyance, but they're just making up their deadlines and they're going to send it back to Chutkan. And I guarantee you, okay, this is giving Chutkan an opportunity. As soon as it comes back to her, she'll say, well, I mean, they already had this. And it's nice and organized. Remember, Chutkan was the same judge who said Trump and his defense didn't really need to read all the discovery, all the evidence, because it's a lot. It's like 13 million pages. You know, that's a lot. That's like way more than Walmart versus Visa. Okay, that took 7 years to litigate. This is just like 9 months to litigate. It's double the amount of pages, like 7 million, like 14 million in this case. They took 7 years. This is like 7 months, you know, whatever. So, and she said Trump doesn't need to read it because he's probably not going to read it all anyways, which is insane. And also that Molly, the highlighter girl from the DOJ, was organizing everything with sticky notes and tabs, you know, and keeping things all chronicled with a nice index. And it was pretty. And Judge Chutkan said, I really love the colors, what you've done here. It's beautiful. So she said, yeah, you guys don't need to read it. Plus, the government already told you what the strategy of their case is, and they already told you what they think your defenses are, and that's good enough for you. So they say, all right, so this is now deranged thug Smith writing, saying, all right, Judge, the court has the responsibility to maintain decorum in keeping with the nature of the proceedings. Now, the judge is not a mere moderator, but a governor. Now, as part of this responsibility, the judge has to shield the jury from improper evidence and argument. And to that end, the court must also exclude any evidence that they deem irrelevant. And remember, this is DC, and we've covered many DC cases, many January 6 cases here, including the Proud Boys and the Oath Keepers at length. And we learned that in those trials, the courts were very, very partisan with what they deemed the word relevant to mean. If you wanted to, say, for example, introduce evidence about Homeland Security investigations, you know them as HSI. They said, no, we don't need to talk about HSI. You only get to use the FBI. Okay, you get those 3 letters, FBI, not HSI. And we said, well, the defense has a bunch of evidence that Homeland Security had dozens, if not hundreds, of other undercover agents, undercover informants, CHSs, who knows, that we would like to admit as evidence because the defense thinks that's relevant. But the judges just said, no, that's not relevant at all. You only get to talk about the FBI because that's all the government needs to convict you, and they're not using any other evidence, and so it's irrelevant for our purposes, and so the whole thing was rigged. So Jack says, because relevant evidence is that evidence which has any tendency to make a fact more or less probable, it's an important thing for the judges to do. And here, they've gone through some other cases, okay, out of the DC district. In this case, United States versus Easterday, that court found that they prohibited a January 6 defendant's argument. Okay, he tried to make a J6 argument because there was not sufficient evidence from which a reasonable fact finder could find for the defendant on that theory. All right, now, so this is some judge, a Washington, D.C. judge like Chutkan, maybe Chutkan, I don't know, who takes a look at the defense theory saying, you know, I don't think that the Proud Boys were responsible for the insurrection or whatever they claim, right? Or for a seditious conspiracy. No. In fact, we think the conspiracy was that the FBI had Proud Boy informants who picked up Enrique Tarrio from jail out of DC the day before. How about that's a conspiracy that we would like to offer as counterpoints to your so-called conspiracy of seditious conspiracy? And the judge says, well, no, I mean, if you look at the facts on this case, there is no evidence, not sufficient, that there's a reasonable fact finder, okay, which is some idiot moron DC juror, with all due respect, who votes Democrat 99% of the time, who could find for the defendant on that theory. Of course not. No reasonable DC Democrat would ever think that the government is responsible for a security failure or even inciting what we saw there on January 6th. They don't even want to talk about Homeland Security. So the proponent of the evidence bears the burden of establishing the relevancy. And so all the courts just say, well, that's a conspiracy theory. And they dump it all. And this is going to happen with Trump, by the way, okay? When this comes back at some point, Chutkan's going to say, yeah, you don't get to make any of those arguments, Trump. Now, here's Jack. He says, even if evidence is relevant, the court may still exclude it if its probative value is substantially outweighed by a danger of unfair prejudice. Okay, this is a big rule that we talk a lot about, Federal Rule of Evidence 403. And it's basically a balancing test, right? So you've got this scale right here, and you have this little lever that you balance, and you say, is this probative here? And if it's very probative, meaning it answers questions about that you need answered, if it's more probative than it is prejudicial, then we allow it in. But if it is more prejudicial than it is probative, then we keep it out. So you're asking yourself about what amounts to prejudice and what amounts to probative value. So the balancing test is here. Unfair prejudice. Also, this can be things like confusing the issues, misleading the jury, undue delay, wasting time, or presenting cumulative evidence. Okay, anything like that is too prejudicial. It hurts the case in some way with time, effort, cumulative evidence, jury confusion, and so on. So they say the right to present evidence is not unlimited. So Trump's defense needs to be reasonably restricted. Indeed, it's incumbent on the court to focus on the central issues and exclude evidence about rigged elections or rigged security failures, or, for example, Stephen's son complaining that Nancy Pelosi and the sergeant at arms at the House were just kind of, delaying any response. They say here in this case, Donald Trump has repeatedly, writes Jack, levied baseless political claims. And that's the word always, okay? Every time you see that word, it's like, oh, bingo. So everything Trump said is true. Bingo, got it. Say he levied baseless political claims and evidence or argument that serves only to support a jury nullification argument and has no relevance at all. Now, as the DC Circuit Court has explained, a jury has no more right to find a guilty defendant not guilty than it has to find a not guilty defendant guilty. And the fact that the former cannot be corrected by a court does not create the power to misapply the law. Now, this is because equal right to justice and blah, blah, blah. Now, that's their, buttering up of the judge, all right? You've got to make sure that Donald Trump And Chutkan, can't stand the man, wanted him already in prison when she was sentencing other J6ers and failed to recuse herself as after we all busted her. But here is what they make now to her. Now that they say, Judge, you got to keep control of this. You have some legal precedent to do it. We're doing this even though all these dates are held in abeyance. This whole thing's kind of illegal right now, but thanks for considering it. So you can start preparing. And this is also giving the judge a bunch of time to prepare her responses, right? And the judge can start to theorize about how she's going to, continue on in this case. So now we get to the argument, some of the good stuff. They tell us, Donald Trump, writes Jack in his Deranged Thugs, he has made clear his intent to introduce evidence and to make arguments that Jack Smith says are improper, whether because they have no bearing on his guilt or innocence or are otherwise irrelevant, or, according to that balancing test, they're substantially more prejudicial than they are probative. And so therefore, Chutkan, you should exclude his arguments. Now, they say the government bases certain of its arguments in this motion on topics that the defendant has explicitly and implicitly indicated through statements and filings that he may raise. For instance, they say Donald Trump and his defense, they move to compel discovery, right? Force Jack Smith to give them evidence that Jack Smith does not want to give them. And now the government, this is your government prosecutors, okay? Trump says, can I just see the cards that you have, okay? Which is my right under due process. Can I see the evidence that you put in your giant tranche of 14 million pages or whatever the number is up to now? So they say we filed to compel. Jack Smith is now trying to exclude the evidence at trial. All right. Trump says, I need to see that. And they say, well, we're not going to use it anymore. What? Well, we want to use it. And they say, well, we're not using it. So you can't use it either. And the government thus reiterates in its filings certain arguments made in opposition. They say, in addition, Trump raises future additional topics that should not be permitted at trial. The government may file additional motions in limine, like this one. It's a preliminary motion to tighten up the trial before we get there, to exclude them in any other future scheduling orders. So we're going to just file away, says Jack. And if Trump was so guilty, this is a point we make here often, just show us everything. Release the footage, show us all the evidence. If he says, can I use that evidence? They say, well, no, you can't because we're not going to use it either. Well, we still want to use it. They say, you can't. It's not relevant. Judge Chutkan, please preclude this. So here's their argument. They say, Judge Chutkan should exclude evidence and argument that does not bear on guilt or innocence, which is part of the reason they didn't charge him with insurrection and all of these other charges like seditious conspiracy. Because then he would be able to rebut those charges, right? He didn't commit an insurrection or commit a seditious conspiracy, obviously, or these other crimes. But they didn't want him to be able to make arguments against those other charges. So they narrowed the scope of their prosecution, even though, like broken records, they keep calling it insurrection. They keep telling us that he led a coup to interfere with American democracy, blah, blah, blah. They say, Judge Chutkan, following Trump's indictment in this district, Donald Trump has made unsupported and politicized claims of selective and vindictive prosecution. The filings we read here, which were quite good, indicating that Trump intends to explore what they call are irrelevant issues related to the government's investigation, and he even complained that the grand jury indictment and the trial date will interfere with his political activities, which is obviously that they will. They scheduled this trial to start the day before Super Tuesday. Come on. None of these issues goes to the defendant's guilt or innocence, and so all of them should be excluded. Okay, so Trump can't talk about his innocence based on Joe Biden making a mandate that Merrick Garland stop acting like a big weenie and do something about this. Merrick Garland did stop acting like a big weenie, and then did something, went and appointed an illegitimate appointed person named Jack Smith, who's not even constitutionally authorized to be in his office, is now doing the bidding of Joe Biden, okay? That delegitimizes the entire prosecution. And they say it has nothing to do with guilt or innocence. It's a partisan weaponized political prosecution. It's the crux of the defense in many ways. So he says Trump should not be allowed to talk about that because it might confuse the jury. It might be too prejudicial, right? And they only want, in other words, we have the hula hoop. They only want to talk about the very narrow, limited charges. That's it. Trump saying that the whole thing is compromised should be precluded. Now, continuing, the deranged thugs write, the court, Chutkan, should also prohibit Donald Trump from introducing evidence, making arguments, or framing questions to advance a theory of vindictive prosecution or otherwise, what they say is improperly inject politics into the trial. Even though this entire case is political, obviously. They tell us that Trump has made baseless claims, meaning they're all true, and has repeatedly levied the false accusation that the indictment returned by a grand jury of citizens in D.C. on a finding of probable cause was directed by the current president as a form of election interference. All true. Okay. And that is documented by like the New York Times, I believe, saying their sources said Biden was upset with Garland, made a statement, Garland turned around, indicted him, appointed Jack Smith, who then indicted him. And Jack Smith went really quickly because he got all of the J6 garbage, and they were already working on this with Molly and Jay Bratt. He just came in, gobbled them up from DC. So in addition to being wrong, says Jack, these allegations are also irrelevant to the jury's determination of guilt or innocence, and it would be prejudicial to them, and so it must be excluded. Like if you followed the bouncing ball from Joe Biden to Merrick Garland to Jack Smith to Trump indictment, yeah, you could see it clearly, and they would be freaked out if the jury saw that. And so Jack Smith says, no, don't show them that at all. Says, no, this is not a defense to the merits of the criminal charge. And consequently, once the court resolves the motion to dismiss based on selective prosecution, he should not be allowed to bring this up again. They say Donald Trump should be prohibited from raising these issues. Whether the form comes in the form of an argument or through the use of terminology they don't want, it makes them so mad. So just make sure you always call it this, always. The Injustice Department, okay, that really irks them. So the Injustice Department, like they think that, like they wake up with this veil of impartiality. Like they think they're doing justice. I've met many of these people, prosecutors all over the place. They like get a badge and stuff and they're like, yeah, we're fighting justice, saving America, cleaning up our streets, all this crap. Okay, look what they do. So when you say that, it shatters their whole facade. It's like an identity crisis. It's just perfect. So when you call it the Biden indictment, which is absolutely what it is, he runs the Justice Department. They keep having this fiction that there's separation here. Or similar phrases, they should not be allowed to use that in the presence of the jury. It is Biden's indictment. It is injustice. Why would they call it justice? Okay, like the Justice Department, because that's your official name. Why don't you just call yourselves absolutely not partisan hacks department? Okay, so every time somebody has to refer to you, they have to say the absolutely not partisan hacks department. You know, it's like whatever you want. Or we can call all the prosecutors honorable and infallible Justice Department. The always esteemable, never wrong DOJ. Like that's their official title and you have to refer to them all the time. Okay, it's their propaganda. We're not going to use Justice Department. What are you talking about? There's no justice happening there. So injustice is just as appropriate. Now, for the same reason, they say Trump should be precluded from raising irrelevant, as they call it, political issues or arguments in front of the jury. Doing so would improperly suggest to the jury that it should base its verdict on something other than evidence, which they're going to do anyways. Okay, it's Washington, D.C. It's like 90% left. They're going to convict. They've convicted everybody. There's been like 2 trials out of January 6th that have gone in favor of the defendants, like 2 out of how many? Just look at it from a statistical analysis, okay? Pick any other jurisdiction in this country. Does any other court have like a 99% conviction rate in America? Talk about a jury of your peers, all right? It's not. It's all a sham. Show trials day after day. So Donald Trump wants to present some of that evidence and they say, no, you can't do that. His current political activities bear no relevance. It certainly does. The whole entity is corrupt. They say before this court, Donald Trump has repeatedly used rhetoric that may be acceptable on the campaign trail, but not in trial. Now, he described his 2024 candidacy He declared, defense counsel in this other filing declared that Trump's comments that attack the veneer in this district were born of concern for deep problems in this city that need to be addressed. All true. Now, these appeals, while permissible in the political arena, regardless of their accuracy, would be impermissible if made to the jury because they risk jurors' substitution of individual standards for the legal standards about innocence or guilt. That is jury nullification. And our courts do not like that at all. They don't even like you. You can't even say it. They get mad. Now, if you go in there, hey, you have a right to, you don't agree with marijuana laws, you can just vote against it. Can't do that. Observing that mitigation, says here, and the court said, I intend to keep politics out of this, right, as she scheduled the trial for March 4th. So they say the court should not allow them. Jack Smith continues writing, the court should also prohibit Donald Trump from trying to baselessly inject politics and impeaching the investigation, right? So he can't talk badly about this corrupt, rigged investigation. They say Donald Trump, through his groundless demand for discovery, he would just, how dare he ask for evidence regarding investigative misconduct, his groundless demand, which means it's absolutely full of ground. The defendant, Trump, has suggested that he intends to impeach the integrity of the investigation, which has none, by raising wholly false claims such as the government's non-existent coordination with the Biden administration. Yeah, right. Oh my gosh. I can't wait till they respond to this. It's going to be a lot of fun. Make sure you're subscribed. And because we know that they were coordinating with them. They got records from NARA, okay? They got records from the January 6th committee, which went over to the Biden administration and to White House counsel so that they could just kind of glean through it and delete the bad stuff before it went over to Jack Smith. They say these are other empty allegations recycled from the selective prosecution motion, which we've already read through here, that's based on anonymous sources in newspaper articles, right? Like the New York Times. Now, although the defendant is entitled to cross-examine the government's law enforcement witnesses about matters that are within the scope of their direct testimony, right? So they're going to keep that very narrow so that they don't go outside of the lines. Trump cannot raise wholly irrelevant topics to try to confuse and distract the jury. Now, much as Trump would like it otherwise, the trial should be about the facts and the law, not politics. But Jack Smith, the entire prosecution is done based on politics. Now, a general claim of government misconduct, they say, is not an issue properly before the jury. Now, although Trump has suggested that he's going to try to raise a claim to impeach this investigation, which is what you do in all criminal law. Okay, when you're being prosecuted for a DUI, you know what the defense is to a DUI? They tested the blood wrong, right? They failed to conduct the field sobriety tests appropriately. It was an illegal stop. Every part of the investigation was garbage. That's the whole strategy in every criminal case. They didn't find evidence appropriately. All of that needs to be precluded. You impeach the investigation in every case. But Donald Trump, not allowed to do that. Not allowed to say that his prosecutor, which is Merrick Garland vis-a-vis Joe Biden, is corrupt. They say it's merely his unsupportive prosecution, selective prosecution claim, and the jurors should not be allowed to hear it. They write, similarly, this court should prohibit Trump from arguing to the jury any legal issues that are properly reserved from the court. Like Trump's other motions, he filed another one. He said that he's immune from prosecution and that his fraudulent statements are protected under the First Amendment. But the court, Judge Chutkan, should deny these claims. He can't make these claims to the jury. Those are legal arguments. Any attempt to suggest or argue to the jury that it should acquit him based on the principles of immunity of the First Amendment would usurp our role to decide legal issues and invite jury nullification. And of course, we don't want to do that. Now, I don't think there's any real risk of that in Washington, D.C. anyways. I think that they could, Jack Smith could probably just walk in and just say, Donald Trump is guilty. And then every juror would say, oh, yeah, you're right. He is guilty. Give me the jury form right now. Right? They'd be done in 2 seconds. Now, we'll see. But that's my take because that's been the pattern on all the other January 6th cases. especially when the judges are contorting them so that certain evidence that the defendants want to get admitted is not allowed to be admitted. Now, they say the court should also prohibit evidence, they want more evidence gone, and questions and arguments about the potential consequences of a criminal case or conviction. They say, as in any other case, the consequence that Trump may face as a result of this may not be considered by the jury. And this is a standard rule in criminal law. You can't go in. If you convict my client, he's going to prison for 30 years. Like, you can't say that. That's for the judge to sentence, not for the jury to decide. It'd be nice if you could. Maybe they'd think about it before they pulled the trigger on those things. But these include the consequences that he may face if convicted, as well as the burden of the trial himself. And so he should not be permitted to raise these issues. Under this well-established law, they say, that's irrelevant. It invites the jury to be confused. And so I don't think that they're going to put up much of a fight on that one. Now, they just don't want him to say that it impacts the election, but this is really more going towards the consequences of the conviction, okay, like collateral consequences and stuff like that. Now, carrying on, they say the court should also exclude any irrelevant and prejudicial evidence and argument, listen to this, about January 6th, which is confusing to me because this is the January 6th case. Jack Smith is prosecuting him for this one out of January 6th, even though it's illegal because he's illegally appointed, but also because Trump is immune, and also because Trump has already been impeached and acquitted. And this is double jeopardy. But my friends, I thought that the left was caring about transparency. And if this is an insurrection that's so obvious, why can't Trump present evidence about January 6th? It's the January 6th trial. Like, that's the whole point of why we're here. So Jack, why can't he bring it in? Let's see. He says, throughout this entire litigation and his public comments, Donald Trump has sought to blame others for the attack on the Capitol. Oh, you mean like the FBI agents who were there? Who were shooting people in the face? Or the Capitol Hill police who were doing that from the rooftops? Or was it people who were working with Ray Epps and all of the other undercover informants? Could it be the 50 individuals that the lawyers for the Proud Boys identified and tried to get admitted into their trial but were precluded from doing so? Maybe Capitol Hill Chief of Police Stephen Sund has an opinion on this. Maybe the Sergeant at Arms in the House of Representatives under direction of Nancy Pelosi should have done something about it. Okay, security for the Capitol building was not Donald Trump's responsibility. But they say that he's going to be blaming other people, like these people who should have actually secured the building. Law enforcement, military forces, which Mayor Muriel Bowser rejected when Donald Trump submitted a request to her. Can we please deploy people on January 4th? She responded on the 5th and said, no, don't put any people in my state, in my district. Unidentified secret agents, of whom there are probably well over 100. We had 50 that the Proud Boys defense identified. And foreign influence. Now, they say Trump should be precluded from introducing within the courtroom the disinformation he has propagated outside of it. And I've seen just evidence of this, and we've covered much of it here. So they don't want J6 evidence that makes them look incompetent or look like they're complicit. So the court should exclude evidence regarding agency preparation for and responses on January 6th. Why don't they want us to talk about that? Oh, they say Donald Trump has signaled his intentions to blame the events of the January 6th on the Capitol Police, who failed, the National Guard, who were rejected, and the district's mayor, who rejected the National Guard and said, we got it covered, literally in a letter we read here many times. We've got it covered. We've handled all this before. Leave us alone, Trump. Because they were saying Trump was going to bring in the National Guard to stay in power. So he did blame the National Guard on this. They were at fault, attributing the riot to the Congress and the mayor. They were in charge of security, and they did not do their job. So the defense, they say, this strategy is factually false. No, it isn't. Read Stephen Sund's book. And it's precluded by the rules of evidence. They say courts in this district in Washington, D.C., which is not a legitimate entity of the justice system that we have, they have overwhelmingly rejected attempts by other J6ers to shift the blame to law enforcement. Well, they say, fine, it's irrelevant. Now, they say, well, additional measures could have been taken to further restrict in the area. But as a legal matter, these shortcomings did not sanction their criminal conduct. So even though law enforcement failed, it is their fault still. But they're not blaming these people as being the causes, okay? They are blaming Trump as being the cause. And so Trump is going to the causation of this. And he's blaming them for being the cause, saying, I am not. Now, they say a bank robber cannot defend himself by blaming the bank security guard for failing to stop him. And Trump cannot argue that law enforcement should have prevented the violence that he caused and obstruction that he intended to obstruct the counting of the votes by Mike Pence. And so they say Trump's criticism of law enforcement fails the balancing test, the 403 test, more probative or more prejudicial. They say it has no probative value at all. It also seeks a series of collateral mini trials, and we would debate all these other issues. Like we'd have a trial about whether Mayor Muriel Bowser could have better responded. Of course she could have, but she rejected them on purpose, in my opinion. Now, bearing at least only very weak logical connections to the central issues. It's not a weak logical connection. They say Trump intended for this to happen. We have evidence that Trump's administration, before it happened, tried to increase security so that stuff like this doesn't happen. They rejected it. And then they say, now Trump intended to do something? This is pure evidence of trying to mitigate harms, not exacerbate them. But they don't want Trump to admit that evidence. And Chutkan's probably going to keep it out at some point. Now, in addition, as part of our analysis, the court should take into the account the security concerns the evidence may raise. Aren't you tired of this one? They say there's evidence, they want evidence precluded from Secret Service operations because that was irrelevant, it would be inappropriate, and it may create a security risk if we all hear about it. Now, barring defense from also questioning witnesses about the precise location of surveillance cameras and other things. It's my national security concern. Jackson lawyers as deranged thugs continue. They say the court should also exclude evidence regarding purported undercover officers, okay? Don't talk about these secret agents in the crowd who exacerbated and incited the whole thing. They don't want any government sources at the Capitol being discussed, right? And we saw this play out in many trials in the J6 cases. They say here, Trump also appears poised to blame undercover agents, of whom there were many, government informants or other CHSs, confidential human sources, also known here collectively as undercover actors. They say Trump promoted internet articles about this on his Truth Social posts. But they say information on this topic is irrelevant to any charge or valid defense. And allowing it would only confuse the jury and waste time. And so the court should exclude it. Don't talk about the hundreds, probably, agents who were there. They say evidence about undercover actors holds no probative value here. As the defendant has acknowledged, there are other cases where J6ers have tried to use this, and the courts have said that that evidence is irrelevant unless they can say that the undercover actor affected the defendant's actions or mental state. Now, they say there is certainly no evidence that Trump had contact with or knew any of these undercover people, and he certainly didn't know them on January 6th or at the Capitol, where he promised supporters he would join them. And so no such actor, therefore, could have affected Trump. Okay, so Trump didn't interface with these people. So he, Trump did not specifically do it. But they're going to blame Trump for everything. Okay, the things that he said impacted a bunch of people that he never had any interface with. But the undercovers apparently had no influence on those same people. Okay, it was only Trump's statement. And because Trump didn't have a specific connection with these undercover agents, he can't use them, according to Jack. Now, if instead Trump seeks to blame undercover actors for causing rioters to perpetrate the violence and to obstruct the certification, that argument is inadmissible. You can't blame the cops who were instigating and picking up people like Enrique Tarrio out of jail and driving them back into the city. saying that argument is admissible because he's just trying to blame others. He's trying to blame law enforcement. He's trying to blame foreign influence campaigns below. No, he's trying to blame the FBI for coordinating and orchestrating the whole thing by moving the pieces around, literally driving them to the scene. How often did that happen? We know that the Whitmer plot was created by the FBI. So what happened here? Where's the pipe bomber? Who the heck was that? Whether others, including these views, are meritless, they say this was disruptive. It makes it less likely that this should be admissible. So they say, even if Donald Trump could provide a cogent argument for the relevance of any of this, as we just have here, the court should properly exclude it for posing an undue risk of confusion. It would be very confusing if the DC constituency realized that there were hundreds of feds in the crowd. It'd be pretty good for America to know that too, wouldn't it? They say allowing Trump to introduce evidence about undercover actors would inevitably lead to confusing mini-trials, such as the identities and the intentions of these undercover actors. No, not at all. No, not at all. We just want to say that there were other causes that were not Trump. For example, it may require the government to introduce new evidence that they don't want to do to show the people whom the defendant alleges who were undercover actors were actually his supporters. Well, why can't they do that then? Again, like if that's true, they should say to Trump, introduce whoever you want. Any bad undercover actors were not bad. We can explain them all. Bring them out one by one. Yeah, that guy. Oh, yeah, that's your guy, not ours. That guy, that's your guy's, not ours. Not ours too. Yours. Clear as day. But they don't want Trump to be able to do that because these guys were not innocent actors. Okay, they were there instigating the whole thing. So, but they don't want Trump to talk about it. So such evidence should therefore be precluded. Now, they also want evidence of any alleged foreign influence, which is curious. Oh, what foreign influence could have been here? They say Trump has indicated that he wants to introduce evidence of foreign influence in 2020, saying he was personally tricked by foreign disinformation. And two, that the January 6th riot resulted from efforts by foreign actors to influence public opinion. They say that evidence is also irrelevant and it's just a confusing sideshow. So as to any claim that Trump was fooled by foreign influence, absent a concrete showing that he relied in good faith on that and that there was specific foreign disinformation, such evidence is going to be irrelevant to his mens rea and it's only going to distract from the jury. Here, now shifting attention to purported false claims made by unspecified foreign actors poses a similar risk, and that should be excluded. They say any argument that foreign actors, rather than Trump and his ceaseless, knowingly false claims of election fraud, which they're going to have to prove that one, I think they're going to have a hard time doing that, were responsible for inflaming his followers and causing the Capitol riot is nothing more than a third-party guilt defense. No, he's saying the FBI did that. He's saying HSI did that, right? And that you created an environment in which when you start shooting people in the face from the balcony of the Capitol, there's going to be some reaction to that. And so they caused it. Now, evidence of the third-party guilt fails the balancing test, and so we got to keep it out. They say courts weighing this evidence generally require a high standard, but here, any defense from Trump that a third party was responsible for his crimes contravenes the rule. They say Trump has not pointed to a single piece of evidence indicating that foreign influence rather than his own lies motivated the rioters. And in any event, whether others, be they civilians or foreign actors, whether they said untrue things on the internet does not exonerate Trump for the lies that he told to his followers. Now, this is all kind of a new section here, right? We haven't seen in our readings of the filings in this case, Trump saying I was duped. Like we haven't seen that argument that Trump says I was, just effectively duped. Now he's referencing another filing in a defense motion to compel discovery. Now I think what Jack Smith is doing here is being dishonest. I think Trump in his filing was asking for evidence about foreign disinformation. Okay, like he wants to know, what did you guys get? What did you have any information about foreign influences on the election? It's part of discovery. You're saying that there was no evidence of any election interference. So Trump in his motion to compel discovery says, we want any evidence about foreign influence that is in possession of any agency of the federal government so we can prove our point. And Jack Smith is now taking that and perverting that. And he's now saying that Trump basically he's taking it one step further and saying Trump is going to use that evidence of foreign disinformation to say that he was duped and he was just fooled. But we have not read that argument here, so that you can see what they're saying here. So Trump is going to try to say, no. I legitimately believed that the election was rigged, but I was relying on foreign misinformation. And so I'm not guilty because mentally I didn't have a guilty mindset. But we haven't seen that argument. Okay. Trump, I think, believes it was rigged because it was rigged. And whether it's not misinformation, it's not like this is not true, right? The whole point of Trump's defense is that it was actually rigged. And as the chief executive, he's got the responsibility to ensure that we don't have rigged elections. Now, courts weighing the probative value of this, we see that. They say the court next should exclude evidence of post-crime changes to the election law, right? And they all told us that Donald Trump didn't have the right, or that Mike Pence didn't have the right to actually reject the votes. Of course they did. Why? How do we know that? Because they changed it. They took that ability away from him. And now Jack Smith doesn't want us to talk about that. So after the 2020 election, governments and courts made changes to various laws and rules. For instance, the Electoral Count Act already prohibited what they said was Trump's criminal attempt to misuse the VP's role. But I disagree with that, right? Now, I actually said that at the time that I didn't think Mike Pence had, there were a lot of interpretations here, but that he didn't have the ability. Some people said he could select which one went in. And I basically said, no, I thought that he could reject them. And then there could be a debate about it. But so there were debates about what Mike Pence could do and whatever. But there were debates about it, right? It wasn't cut and dry. And so Donald Trump saying that Mike Pence had this authority is not a criminal attempt. How do we know? Because Congress changed the rules after the fact to ensure that this would not be repeated. They made it clear. It wasn't clear. That's how the laws work. In public statements, however, Trump has claimed that subsequent election changes, including the ECA change, somehow legitimize his efforts to pressure Pence. He told an interviewer, he said, well, why'd they change the law then? Saying that you can't do it. They strengthened the law, meaning that you could do it. They literally changed it because they didn't like the outcome. But the court, says Jack, should exclude any evidence of any post-crime changes. They have no bearing to whether his claims of fraud were true, and it could not have been relevant to his state of mind or intent. Okay, so the law that was on the books at the time that his entire team of lawyers was analyzing is not relevant to his state of mind. It's an obviously insane statement. So they say, given this lack of probative evidence of changes to the law would just mislead the jury, and so we don't need them here. We'd have to respond if Trump brings this in, and so do not allow Trump to talk about this change. And finally, they say Trump should not be permitted to introduce improper evidence that constitutes speculation about his thoughts or belief. They say Donald Trump's state of mind during the charged conspiracies are going to be a key issue at trial, obviously. Now, both parties are going to introduce circumstantial evidence of Trump's state of mind, and Trump may himself choose to testify. I hope he does. But the defendant should be precluded from eliciting speculative testimony from any witnesses other than himself about the defendant's state of mind or about his beliefs about claims of election fraud. So they want to prove Trump's state of mind with their evidence, but not Trump's state of mind with Trump's evidence. Isn't that fun? That's your impartial prosecutor with the so-called Justice Department. In the particular circumstances here, this would be an ultimate issue for juries, and it would be speculative and unhelpful, and so thus it should be excluded. Now, each speculation from witnesses violates the rules, and it's not helpful to the juries. And so instead, Trump should only be permitted to examine witnesses about what they personally observed about him. For example, his interactions and other things. Saying a witness cannot perform an opinion based on personal knowledge if it's Trump's own statements. And so here, any witnesses who are testifying about personal observations and speculation would risk prejudicing the jury, and we don't want that to happen here. We don't want witnesses to guess at what Trump might have believed because it's just going to confuse and mislead the jury. So allowing witnesses to share their personal views about Trump's state of mind is just going to distract everybody. And because witnesses and their personal opinions about Trump's belief or Trump's knowledge, because it has little or no probative value, it's going to lead to improper conclusions. And so nobody can come in and testify on behalf of Trump. Similarly saying, stop cross-examination if Trump's going to ask questions about things that we think is protected. The government anticipates calling witnesses with knowledge of information protected by certain privileges, including the attorney-client privilege and the speech or debate privilege. But if questioned about those witnesses are going to attach privilege to those things. And Trump shouldn't be able to ask questions unless he gets clearance from the court. If you allow Trump to question the witnesses about information when they must assert a privilege, if they say, I invoke my right to remain silent, I invoke legislative immunity, I invoke executive privilege. If they do that in front of the jury is going to think that they're lacking candor. So don't even let Trump ask questions about it because it might make us look bad. They say, for all of this, Your Honor, this court should exclude all of this evidence against Trump and saying that this has no bearing on this case, it's irrelevant, and it's more prejudicial than probative. Signed by none other than Molly Gaston, highlighter girl from the illegitimate special counsel's office there in Washington, D.C. So the January 6th trial, as it moves forward, they don't want much evidence of January 6th to actually be presented. They just want to circumscribe what Trump is allowed to say so that they can control the narrative in their fake show trial. Here's what Donald Trump said in response to Jack's motion. Trump writes, responding to Jack, he says, crooked Joe Biden and his errand boy, deranged Jack Smith, is so obsessed with attacking President Trump and interfering with the 2024 presidential election, and is so sad that the Supreme Court just unanimously rejected his desperate attempt to rush this witch hunt, that he is ignoring the law and clear instructions from District Court Judge Chutkan, who unequivocally stated that this case is stayed and there should be no litigation, period. And so Trump obviously not happy about Jack, and Jack Smith's filing will get a response from Donald Trump's team. And motions in limine are very common, and we'll see what Judge Chutkan does. I think she's likely to grant a lot of that. And that's because this district has done this for quite some time. In DC, they have a pattern of finding against the defendants, and we'll see where it goes. But Trump is going to reply, and I think the reply is going to be very spicy, saying, stop filing illegal motions in our courtroom. And so, my friends, we'll be here to continue to cover this. If you want to get any of the PDFs or sign up for our daily newsletter, you can head on over to robertgovea.com. This will be uploaded there. We have our shop that's available there as well, where you can buy a new hat, a new shirt, a gift card, some flip-flops, whatever you want. Great way to support the show. We love when you sign up for our newsletter. That way we can stay connected, and we'll be going through this together. Thank you for subscribing, my friends, and we'll see you right back here on the next one. Now, we're not done yet. We've got to turn our attention over to Michigan and see what's happening here. Donald Trump victorious in Michigan. This comes after the Colorado Supreme Court said that Trump cannot be on the ballot there before they stayed themselves. But Trump is victorious here, and it's out of a short order from the Michigan Supreme Court, which we are going to read through. We've also got some reaction to what's happening in Colorado. CNN is saying, there's no specific threats against those judges. Remember when Lisa Monaco was saying, our DOJ agents are under attack, and Colorado police are warning that the Colorado judges are now under attack. Okay, well, there were no real specific threats. It was all just made up. And also, we now know that the biggest donor behind some of these removal efforts is none other than George Soros, of course. We've got the actual ruling out of Michigan. The Supreme Court, they are finding in a very short order Donald Trump is staying on the ballot. You see, the case is the Secretary of State and Donald Trump. The people who are filing this is Robert LaBrant, Andrew, Nora, and William. These are the plaintiffs' appellants, and they are trying to get the Supreme Court to accept the case in Michigan. But the Supreme Court says, sorry, not going to do it. They write, on order of the court, the motions for immediate consideration are granted. Now, the motions from the RNC, the National Republican Senatorial Committee, and the Congressional Committee, along with these other people, and Citizens for Responsibility and Ethics in Washington, they have all filed briefs, and the court is considering those as well. Now, the amicus briefs submitted are also accepted, and they say the application for leave to appeal the lower court judgment from the Court of Appeals that was entered on December 14th is considered and denied. That's it. Because we are not persuaded that the questions presented should also be reviewed by this court. That's it. That's the opinion. So basically, they're just affirming the lower level Court of Appeals. So it went from the lower court up to the Court of Appeals, up to the Supreme Court. And this here, when the case landed here, the decision was Trump wins. Okay, Trump stays on the ballot. And so they appealed it here to the Supreme Court, and the Supreme Court said, we don't really need to take a look at anything. And then we're just done. Okay, so don't even appeal it. Send it all the way back down. The original findings were valid. Trump stays on the ballot. That's the game. So we now have a pretty serious split. We've got Michigan saying Trump is on the ballot. Colorado says Trump is off the ballot. I want to share with you just this dissent from the Judge Welch. You can see there were 7 judges here. We've got Clement, Zara, Viviano, Bernstein, Kavanaugh, Welch, who's the dissenter, and Kyra Bolden. But Welch, it's not really kind of an actual dissent. I think even this judge is mostly agreeing. She says, as I noted in an earlier appeal, whether a candidate is constitutionally ineligible based on the insurrection clause and whether the judiciary can decide that are questions of monumental importance in our system of democratic governance. Now, while I disagreed with this court's decision not to grant the earlier bypass application, they moved quickly, they answered legal questions, and considering the importance of the questions at issue, I believe it's important for this court to consider and issue a decision on the merits, okay? This wasn't, the court didn't consider anything. They just said, what the lower court of appeals did is good. This judge says we should do a little more. Says, the only legal issue properly before the court is whether the Court of Claims and the Court of Appeals made a mistake by saying that Michigan cannot remove Trump from the ballot. Says, I agree with the Court of Appeals that under this rule, the Secretary of State must place Trump on the ballot regardless of whether he would be disqualified under the 14th. So that's basically agreeing with the finding, like he's got to go on the ballot. Now, as the Court of Appeals noted, where the relevant statutes require the Secretary to place any candidate on the ballot, it defers no discretion to the Secretary and there's no error to correct. So it's all good. Now, appellants, the people who want Trump gone, they argue that the state has delegated this role to political parties. Political parties set the people on the primary ballots, and then as doing so, they are basically pseudo-government actors. They say that Michigan courts have recognized that the political parties are agencies of the state, and they say that political parties thus are state actors, and thus political parties are subject to the Constitution, and the 14th Amendment is going to govern them, and so then the 14th Amendment requires that the Secretary of State remove the people. Now, if the premise is true, then they say political parties might have an obligation to ensure that their candidates are constitutionally eligible, but that still doesn't affect the Secretary's limited role and authority. So going back to the law, saying here, you file a nominating petition. This permits the campaign to look at the things. That gives the Secretary of State discretion. Now, while there might be some merit to the argument, no political party is a party to this litigation. And so the appellants have notified the court. They say Trump is disqualified. Okay. Here, they're taking the Colorado case. They said, they're notifying us that Colorado removed him under Section 3 of the 14th Amendment. And they say, well, the Supreme Court decision, there was a lengthy trial there. They developed a factual record. And the legal effect of the decision from Colorado itself has also been stayed for a short period of time. And Trump is going to appeal this. And significantly, they say, by the way, Colorado's laws are very different than Michigan in material ways. This is why they may have gotten what they've gotten, but not here. They quote the Colorado case, and they say, in Colorado, the election code limits participation to qualified candidates, which is not what they do in Michigan. The appellants have identified no analogous provisions in Michigan that's similar to what they have in Colorado. Here, all they got to do is submit an affidavit of identity, and then there's some more things. There's a statement that they meet the statutory qualifications. Any materially false statements are problematic, but Trump is not seeking to appear on the primary ballot through a nominating petition under this law. So he's, if you guys, and basically saying, while the wisdom and the purpose of this law is open to debate, that's for the legislature to handle, okay? And so thank you for this. That's right. The courts can't just decide this stuff. We have a legislature, okay, that gets to change the rules. Now, here they say, Secretary of State under our laws, not legally required to confirm the eligibility under the 14th. She lacks the legal authority to remove a legally ineligible candidate from a ballot. Says, I would affirm the Court of Appeals ruling on this issue, saying that it still allows appellants to renew their legal efforts during the general election. Okay, so this might be coming back. Now, finally, while not adopted by the Court of Appeals, I would also vacate the Court of Claims analysis as a political question doctrine, unnecessary, and for these reasons, I respectfully dissent. So, sounds like it's a technical thing, right? It's during a primary, Secretary of State has limited discretion. Once it transitions over to the general, we'll see these people file a whole slew of claims again, right? Like they'll come back. Whether the court differs or whether the analysis changes all that much is yet to be seen, but they will certainly be back because that's all they know. And now we turn our attention to Colorado. As we saw there, they were the first to remove Trump from the ballots before they stayed themselves. And we've seen some other stories that they were under attack over there for wrecking Colorado democracy and jeopardizing the rest of the country. They said that they were being attacked, and our question was, really? That's interesting, because who's doing the attacking? Is it the FBI, the same people responsible for a lot of the other fake plots in this country? Here is CNN admitting that, yeah, there were no specific threats. There were a bunch of headlines yesterday that we talked about here, but no real specifics. Isn't that interesting?
The Denver police did have to respond to what they said was a hoax report at one of the justices' residences. No specific threats to the justices in those forums, from what we understand. So no specific threats at this time that are requiring law enforcement to make arrests. Those are very non-specific threats at this time. There has also been generally law enforcement looking into the discussion about these justices on online forums, particularly some general discussion among extremists and people who are pro-Trump.
What on earth? That's from Newsbusters Media Research Center. And so they're just making it up. And I guess they're probably listening to this show. Hello, Colorado agents. What the heck are they talking about? Echoing online activity? FBI's working with local law enforcement? Can we not criticize opinions now from other judges who are trying to take away the right to vote for their candidate away from 1.3 million Coloradans? Good Lord, it's literally fake news. They just said, well, they're under attack. Oh, really? What kind of attack? Well, I mean, nothing specific. Oh, so like, did you just make this up? Show me where they touched you on this doll. Oh, they didn't. Oh, got it. Thanks. So here you see is another reaction. Who's behind all of this? Is this about American insurrection and American democracy? Or is this about political opportunists who've got billions of dollars who just funnel it to people who want to get paid? This is a clip from Natalie Winters. It says the founder of the group behind the lawsuit removing Trump, of course, is George Soros. This is the woman who's over there in Colorado as a representative of people trying to remove Trump. And here is what this exchange sounded like.
Find a legal hook to push our issues hard.
Who are some of the biggest donors you have, and is there a restriction on how much money they can give you?
We don't have any restriction, but I would say our biggest donors are, for example, the Open Society Institute is a very big donor.
Who is that?
Whose organization is that?
Well, it's a foundation, but it's well known to be George Soros is the one who funds it. The Wallace Global Fund gives us money. The ARCA Foundation gives us money. Those are some of the big foundations where Carnegie Corporation gives us money.
Yeah.
You do see a thread through the different sides in this where a big donor like George Soros will give to an awful lot of progressive organizations. Does he ever ask for anything directly?
No, and I have met him, and he's never asked for anything at all. And I meet with the program officer from the Open Society Institute, and they're very happy with what we do. And,
of course they are.
They're very keen on transparency. We're part of their democracy. Find the legal hook to.
Of course they are. Yeah, they're very happy with what you're doing because you got Trump removed from Colorado. Nice job. A lot of money being passed around. Okay, who else is getting funded? Who else is donating to certain judges on certain benches to get stuff done? We'll have to see. So, my friends, we're going to be continuing to cover this. Good victory for Donald Trump in Michigan, but it's going to be a long road ahead. Domino effect is in full swing. They're trying to take him out across the country in various different states. We're going to be continuing to cover this. Thanks for sharing this channel and our content with a friend or family member so that they can see what the latest is in all these efforts. It's going to be a political chessboard for the next year. So we'll be here. Thank you for subscribing. Thanks for checking out our website, robertgovea.com, signing up for our newsletter. We send emails every day after the show with summaries and links to everything we covered. And so we'd love to see you sign up there, robertgovea.com, and we'll see you right back here on the next one. All right, my friends. And then we've got one final segment on the day before we hear from you and before we go over to watchingthewatchers.locals.com for our members only after party. Did Joe Biden collude with Hunter Biden to obstruct Congress committing a new crime that might lead to his impeachment? Well, Congress wants to know about this because we remember when Hunter snubbed them, showed up, stood on the Senate side next to stinky Eric Swalwell, and gave the finger to Congress before he left. I'm here to answer questions. And then he got in his car and got the heck out of there. But what happened? Did he communicate with the White House? Because Joe Biden runs the Department of Justice. And if Joe Biden was colluding with Hunter to obstruct Congress, that's a conspiracy. That's a new crime. He should be indicted immediately and impeached and removed. Now, how do we know that there was collusion between the two of them? Well, Karine told us that. And so Congress sent a letter over to them, to the White House counsel, explaining that they've got questions and they are demanding answers. But you remember what Karine said after this happened. She said Joe Biden was familiar with the plan. And we thought, that's interesting. How does he know about that? White House's Karine Jean-Pierre said, yeah, the president was familiar with what Hunter was going to say, which is a basic FU to Congress. So here is what Karine said.
Thank you. Thanks, Karine. You said that President Biden was familiar with what his son was going to say on Capitol Hill. If I called my dad and said, I am about to violate a congressional subpoena, he'd probably say, son, you shouldn't do that.
Not a good idea.
Was there any attempt by President Biden to talk Hunter out of it today?
You're going to call your dad Steve?
Call him Dad, usually.
Look, I don't have anything else to add. The president was familiar with what Hunter was going to say today.
Curious.
And, look, he's proud of his son. He and the First Lady are proud of his son, how he's rebuilding his life back. He's going to focus on what is needed on the American people. Hunter, and I've said this many times, is a private citizen. And so certainly I would have to refer you to
who lives at the White House,
to his representatives. I'm just not going to get into private conversations because what you're asking me is actually a private conversation. I'm just not going to get into it.
First briefing since Hunter was indicted again in Los Angeles. Why doesn't President Biden just pardon him?
President, I've been very clear. The president's not going to pardon
And
his
one
son.
more about these.
We'll see. We'll see if he does. I think we might get closer and closer to that. But that is an interesting question. Karine says Joe Biden was familiar, I would say conspiring with, Hunter's obstruction of Congress. Congress wants answers about Hunter and Joe's collusion, sending this letter on December 27th to the assistant to the president and White House counsel named Mr. Edward Siskel. It says, hey, dear Mr. Siskel, Writing this is James Comer on Oversight and Jim Jordan on Judiciary, saying to the White House, all right, Mr. Siskel, the House Committee on Oversight and Judiciary are investigating whether there are sufficient grounds to draft articles of impeachment against Joe Biden for full consideration by the House. We've got H.R. 918 passed by the 118th Congress in 2023 as reference. They say, along with the House Ways and Means Committee, along with Jason Smith, we set forth in September a memorandum on the evidence that justifies the House's inquiry and the scope of the impeachment investigation. But on December 13th, the House of Representatives directed the committees to continue the investigation. And in light of an official statement from the White House that President Biden was aware in advance that his son Hunter would knowingly defy 2 congressional subpoenas, we are compelled to examine, as part of our impeachment inquiry, whether the president engaged in a conspiracy to obstruct a proceeding of Congress. So the committees issued subpoenas for Hunter for a deposition to be conducted on December 13th. Now, in correspondence with Mr. Biden's attorneys prior to the scheduled date of the depositions, the committees addressed and rejected Mr. Biden's justification for not complying with our subpoenas, as well as Mr. Biden's demand for special treatment from the committees. Now, the committee specifically notified Mr. Biden via his attorney that he and his failure to appear for the depo as required by the subpoenas would lead to the committee initiating contempt of Congress proceedings. We'll see. On December 13th, Mr. Biden did not appear for the depo. He stood outside and scolded you guys. Instead, talked about his addiction. Instead, Mr. Biden appeared on the grounds of the Capitol with his attorney and Representative Eric Swalwell, another co-conspirator. Mr. Biden gave a lengthy public statement to an assembly of reporters in which he made several statements that are relevant to our impeachment inquiry, including representations about his business activities, assertions about Biden's awareness and his, quote, financial involvement in these activities, and attacks on the committee's inquiry. Hunty then indicated that he would not appear for the deposition as required by the subpoenas that were lawfully executed, and that he would only testify in a public forum, a demand for special treatment that the committee has already rejected. Although Hunty professed an interest in answering questions, he then departed the Capitol grounds, ran out of there without taking any questions at all from the press. The committee subsequently recorded Mr. Biden's non-appearance at the deposition. You're not here. So later, crime has been committed. Later, on December 13th, when asked about whether President Biden had watched Hunty's statement, Karine stated that Biden was, quote, certainly familiar with what his son was going to say, as we just listened to. However, Ms. Karine declined, however, to provide any further details on what the president did and whether the president approved of his son-defying congressional subpoenas. Nonetheless, Karine and her statement suggest that the president did have some amount of advanced knowledge that Hunty would choose to defy our subpoenas. So under the relevant section of the criminal code, the answer is it is unlawful to corruptly endeavor to obstruct the proper exercise of the inquiry from Congress. And likewise, any person who aids, abets, or counsels, or commands, or induces, or procures the commission of a crime is also punishable as a principle of the crime. So in light of Ms. Karine's statement, we are compelled now, Hunter and Joe at the White House, to examine the involvement of the president, Joe himself, in his son's scheme to defy the committee subpoena, saying the committees have accumulated substantial evidence that Hunter Biden's business endeavors have improperly included his father, and the president has made false claims about his knowledge and involvement in the schemes. In fact, just days before Mr. Biden was scheduled to appear for his depo, the president, Joe, claimed that he had not interacted with any of his son's business partners, but we know that's false. The president has in fact met with, spoken to, and received money sourced from his son's business partners. In light of this evidence, the fact that Joe has advanced awareness that Hunter would defy the subpoenas raises troubling questions that Congress needs answers to. We must examine whether the president corruptly sought to influence or obstruct the committee's proceedings by preventing, discouraging, or dissuading his son for complying with subpoenas. Did he promise him a pardon? Such conduct would constitute an impeachable offense. And so, Comer and Jordan, they write, accordingly, and pursuant to the impeachment inquiry, which we have now authorized in the House of Representatives, please produce the following information for a period between January 20th, 2021 to present. And we got the full House, the full weight of the House behind this. All documents and communications sent or received by employees of the Executive Office of the President about the deposition of Hunter, including but not limited to emails with Hunty, Winston and Strawn, and Kevin Morris, the Hunter sugar daddy, living in LA. And 2, all documents and communications sent or received by employees of the Executive Office of Biden and his statement about his family's business associates on December 6th. Please give us this information ASAP, but no later than January 10th, 2024. Thank you for your cooperation with the impeachment inquiry, period. Sincerely, James Comer and Jim Jordan, copying Raskin and Nadler on the respective committees. And so a nice letter with the full weight of the House behind them now from Judiciary and elsewhere. And so we'll see if the White House responds now that they've got the full impeachment inquiry at their back. Now, James Comer is explaining his position and some recent updates on the Biden crime family investigation. And we can see him here being asked questions over on the mainstream media.
Laugh about every time I hear the mainstream media. There's no evidence that Joe Biden has done anything wrong. But the money that's been flowing into the Biden, other than Joe,
that something stinks here. Most Americans realize that we've provided bank statements as hard evidence, statements that show the Bidens have received well over $20 million from our enemies around the world, and they can't answer a simple question. What did you do to receive the money? They also know that Joe Biden stated during the campaign he never met with any of these people who sent his family money, and that he had a wall between the government and his family's shady business schemes. We know now, because of our investigation, that he sent dozens and dozens of emails in a pseudonym to many of these business associates. They won't turn those emails over, as you know, Jason. That's part of the evidence we're continuing to seek to receive through this impeachment inquiry. And we know that he communicated with every single person that he said he never met with that sent his family millions and millions of dollars around the world. So the American people know something stinks here. And that's going to be a problem for Joe Biden moving forward. Not only are his policies a disaster, but the American people think he's a crook.
Tell me, go through the list, if you will, just off the top of your head, of documents and things that you're wanting to see that you haven't yet been able to get your hands on.
Well, first, right now, I think one of the most important amount of documentation that we need are those pseudonym emails. Remember, no one knew about these pseudonym emails until a few months ago. We found that Joe Biden was using at least 3 fake names on government emails. What we didn't know until recently was that he was, in fact, using those pseudonym emails to communicate with not just his son, Hunter Biden, but also with his shady business associates. The Politico, in their never-ending defense of Joe Biden, wrote a story when the White House turned over 14 of these emails, which didn't even amount to 0.5%, and said, oh, there's nothing here. These are junk emails. But what we learned from the indictment in California, several of those emails that Joe Biden used a pseudonym were used as evidence against Hunter Biden in his failure to pay taxes. So that is important evidence there. We also need those depositions. There's certainly a reason that Hunter Biden's not wanting to come in and answer questions. We have his bank statements, and bank records don't lie. So we want to depose Hunter Biden. Obviously, we want to depose all of the business associates, but we also need those pseudonym emails, and we also have questions for the National Archives. Which countries were involved in the documents that Joe Biden mishandled? That's something that I think is very important of our investigation, because we've identified, Jason, a couple of emails that Hunter sent to people in Ukraine, for example, that we believe may have been classified documents that Joe Biden mishandled, that were in possibly the garage of Joe Biden's house where his son was living.
There is so much here, and it feels like it's just slowly coming out. Why do you need all these aliases? Why all of these emails? The goalposts keep changing. They say Joe Biden knew nothing about Hunter. Okay, maybe he did, but he wasn't involved. Okay, maybe he was. Maybe he showed up at dinners and stuff, but they only talked about the weather. Okay, maybe not about the weather. Maybe they talked about some other things. Okay, maybe he actually did show up at like some important meetings. It wasn't just to have coffee, and so on and so forth. And now he wasn't financially involved. Okay, but he got money paid back in loans from James Biden, and the money was passed along through entities that were for foreign sources. So the list just keeps changing. Now he's saying my dad wasn't financially involved, which means he must have been very, very otherwise involved. Pseudonyms that they don't want to turn over. National Archives covering up for this. DOJ covering up for this. People like Leslie Wolf fleeing the DOJ to get the heck out of Dodge. And it's all just warming up. I think it's going to time right nicely and climax with the election, which is very curious. It makes me wonder if Joe is going to be around much longer, but we'll see. So we'll be here continuing to cover, my friends, collusion, corruption, conspiracy, obstruction, all in the Biden crime family, and Congress is investigating. We'll be here continuing to cover and do our own due diligence. Thank you for subscribing wherever it is you're watching this. Thanks for checking out our website, robertgovea.com. We would love it if you went over there. Remember, all the reports are on here, robertgovea.com, so you can read any of the PDFs that you want, read a summary of the segment, sign up for the newsletter by clicking that blue button right there. That way you can get the reports delivered to your inbox every day after the show, and we'll look forward to seeing you there. We'll look forward to seeing you back here on the next one. All right, my friends, that is it for us on the day. We covered some good ground. Collusion between Joe and Hunter Biden. Big win for Donald Trump there in Michigan. And Jack Smith wants no January 6 evidence admitted in the January 6 trial. I mean, they should probably just convict Trump like right now. What do you need any evidence for? But now it's time to hear from you. And we are going over afterwards to watchingthewatchers.locals.com for our members only after party. We do members only streams in the morning. We had a great stream this morning saying hello to everybody on Hump Day Wednesday. And so come and join us. We'll be back tomorrow morning with another stream on Locals. We also have a bunch of new YouTube members who just joined us, courtesy of Saint Chef. And so our YouTube friends, if you want to join us on the after party, navigate over on the YouTube channel to the community tab section, scroll down. You're going to find a Telegram link there that's just a members only link. We'll see you there for the after party. And we got some lovely donos in the house. Man, you guys are amazing. Let's see who we have here starting the day off. The Blind Lawyer Explains says, Rumble is not up. A heads up. Yeah, and we apologize on that one. So I tried to schedule Rumble twice today. I think Rumble is having a little snafu today. Our team has also been having some difficulties uploading our content the last day or two on multiple locations. So I've been having difficulties and other people have been having difficulties. So Rumble's not up, but the segments will be up, and we miss you. I mean, I was like scrambling. I tried twice, and it was just, I clicked submit and it just sits there submitting. So I said, okay, try it again, submit again and again and again. Tried it right before the show when I scheduled all of them, and then I tried it right again and it didn't load. So we miss you, Rumble. Hopefully we see you tomorrow. Air Force Vet is here, says, so when is anyone going to do anything about this illegal Jack Smith office? He is not a U.S. attorney, according to the Constitution. It's a good question, Air Force Vet. We're going to see if Trump's attorneys bring that up. But there was an amicus brief also filed with the Supreme Court, and the Supreme Court rejected Jack Smith's claim, but they will be back at the Supreme Court at some point. I mean, whatever happens in the Court of Appeals, whoever loses is obviously going to be appealing that. So at some point, maybe we get some clarity. Otherwise, we would need Congress to probably clarify the role of the special counsel's office. But we need the courts to do something about illegal Jack Smith. I totally agree. The Blind Lawyer Explains says, don't blame me for Rumble being down. The Blind Lawyer is over on Rumble. Is yours working, the Blind Lawyer? I was trying to see if it's not just me, because on my team on the other side of the world is also having difficulties. So we're having problems. Rob White is here, says no reasonable prosecutors torque old bringing such a case against the Democrat. What Trump tweeted? What? Trump tweeted a mean tweet? Impeach him, indict him, arrest him, take him off the ballot. Yeah, no reasonable prosecutor would bring cases like this against the Democrat. And these are ridiculous cases to bring. Like, they're going to prove that Trump knew that his claims of election fraud were fraudulent, were false. I don't believe that for a minute. What's up? Thank you, Rob. Thanks for the nice dono. And thanks for being a membo, too. Hey, Janine C's here, says, thank you, Rob. You are the best. Well, Janine, thank you for saying that, number one. I think you're the best. And this was your first super chat on our live stream. And so, Janine, thanks for submitting that. Very grateful to have you here. We got this one from Rob White. Says no reasonable prosecutor would bring such a case against Democrats. There it is. We got a correction on that. What? Trump said a mean tweet? Impeach, indict, take him off the ballot. Are the gallows built yet? Some others created his own gallows. Yeah, Rob. So thank you for the double super chat and the double great comment. And that's right. They're very upset about Donald Trump. I still don't know what it is. I think it's probably mostly that he's anti-war and they need endless war in order for things to be valid. Thank you, Rob, for that. Brian Masters became a supporter. Welcome aboard, Brian Masters in the house. We'll see you in the after party and on the members only stream. Hey, Rob White says, his filing is illegal. No jurisdiction. The case should be stayed while on appeal. Jack Smith should be precluded, along with all contaminated evidence. I totally agree with that, too. Yeah, he's just getting very excited. He's like, we really need this trial to go. He's like, Judge Chutkan, please read this so that as soon as this case comes back down, we can get this train back on the track. We got B. Torn is here, says Donald Trump will go down in U.S. history as the most significant citizen in defining and solidifying the Constitution and the Bill of Rights. Well, there's no question about it. I mean, Trump's presidency and this whole thing is historic in ways that, like a lot of presidents come and go and it's kind of a boring, it's not interesting. Like Obama, like, did he accomplish anything really other than Obamacare? Like, he was the most inconsequential presidency in recent history. Jimmy Carter's kind of another one. Where things are just kind of like, status quo. Jimmy Carter's was pretty bad, but they're inconsequential, right? Trump is not. Trump has reshifted the entire stinking conversation, right? They're wrecking the judiciary in order to stop him. Like, the whole country is on the brink of a civil war, like legitimately. If Trump wins, especially, I think that's going to be something that you're going to hear from the left. Well, we're breaking away now and all this stuff. So we'll see. So Bitorn, good comment. And Rob White as well. We've got another one from Bitorn. Says precluding evidence is court-approved evidence tampering. What is illegitimate Jack trying to hide? It's a good question. The truth. Because if the truth comes out, then their fake narrative is going to be exposed for all to see. Dolphin Fan is the man, bringing in 5 new membos, and we're going to see if we can dig those up. Thank you, Dolphin Fan, for bringing those in. 5 new membos, courtesy of Dolphin Fan. We'll see if we can give welcomes over there. We got Oil Smoke Jones sharing this one. Says, other leftist election interference trials, the judges just declared the defendant guilty before any trial. So-called default judgment. Why doesn't Chutkan just do that? Well, because this is a criminal case, so it's a little bit different. In civil cases, they can enter defaults. In criminal cases, the alternative is really a trial in absentia, really. But they're not going to do that with Trump because Trump's not in absentia. Trump is here. He's there. And so they can't really, they could issue a warrant if he fled or something like that. But there's got to be due process in the form of a trial. So they're not going to do that here. They're going to actually make him go to trial because it's a criminal case. It's not a civil case, is a real short answer. It's unlike Alex Jones. It's unlike what we saw with Rudy Giuliani, right? Those are both default cases. And this is just a separate area of law. Pinochet's helicopter tour says, okay, so no witness speculation allowed? Well, I guess that, quote, expert in Trumpism code that testified in Colorado won't be invited to the J6 Star Chamber trial. Well, the judge might allow him in, because he's an expert. So, in other words, Pinochet, they're just going to accept the witnesses that are good for their side and reject the witnesses that are bad for their side. It's good to see you, Pinochet. And Felix is here, says, when good is ABS, there is evil. These politicians always say choose the lesser of two evils for the greater good. If greater good is a vessel, then it is full of evil. Interesting comment from Felix. That's some pretty deep stuff there. And I appreciate you sharing that. And we also had, oh my goodness, 50 membos coming in courtesy of Saint Chef. And so, man, we had some very, very nice comments in here. Let me see if we can welcome some of our friends who are our latest members who are joining us. No, my chat history is not going back far enough. All right, so we got 50 new membos. And Saint Chef, thank you for bringing them all in. I apologize that I'm not able to read them all off because the chat is evaporating before my very eyes. We love our very robust chat. But we did bring 50 new membos. So if you're coming in here, that is courtesy, man. 50 are coming in courtesy of Saint Chef. And we got a lot of new membos here. So Dolphin Fan brought in 5, and Saint Chef, very grateful for you. Thank you for bringing in all 50 people. You know who you are. And that's a big contribution. So Saint Chef, you're also a membo. And so we'll see you in the membos only tomorrow. We'll see you in the after party, hopefully here today. We'll see you on our Saturday stream. And we are extremely grateful for you bringing in the newest of membos. Saint Chef in the house, very, very much appreciated. Thanks for expanding our incredible community. And so the rest of my friends, it's very nice to see you guys. We got the old bag, Sam in Texas. What's up, James? What's up, Mike H? What's up, Eric? We got Andrew R. Salty's here. Nana Bright's here. Pinochet says Biden and DHS will invoke NSPD and HSPD 20, I fear. Well, I don't know what those acronyms are, but they don't sound good. Anything from DHS is not very good, especially when they're trying to save us all. You know how that goes. So, all right, my friends, thank you for sending those in. We've got some other comments that came in from our friends on the locals and elsewhere. And let's see who else we've got. What is going on? And so we're grateful to our mods. We got the best mods in the house. We got here from Knox says, that was what I was trying to say earlier. This has to be political. Trump is charged with crimes that are not in any state penal code, but for the RICO charges. It's all executive action. So Trump is being charged for essentially doing his job. It's good to see you, Knox. Thanks for sending that one in over on the locals. Chubby's here, says, if deranged thug Jack Smith wants to keep politics out of the courthouse, does that mean the entire prosecution team needs to not be allowed into the courthouse? Oh, good question. Yeah, because they've got a long history of being partisan hacks that we've covered here. I guess the entire case needs to not be allowed either. I guess they are trying to make things easier for the defense. Yeah, Chutkan says, okay, no partisan political hacks in this case. Sorry, Jack. Pack up your bags. You're gone. Get out. Get out of here. Go, go. We'll see. I don't think that's going to happen. I think she'll just kick out the Trump side. But it's good to see you, Chubby. Thanks for being over there on locals. Says, wow, I always thought the job of the defense in a trial was to introduce alternate conclusions in the event of a question, with enough evidence to convince jurors of reasonable doubt. Clearly, I was wrong, according to Smith's filings. You know, I must be wrong, too. It's like my entire career practicing law of raising doubt. Apparently, according to Jack Smith, I was, spreading disinformation out there with my baseless theories. It's obviously insane. Like, that's the whole point. It's to question the investigation. It's to say every cop's a moron. The crime lab's full of idiots. All of their procedures are bad and problematic. Okay, no one knows what they're doing. They got the wrong guy. It's not even my drugs. That's the whole point. And now when Trump wants to do that, they say, well, he shouldn't be allowed because this could cause another insurrection in Judge Chutkan's courtroom. Amazing. We got some great comments. Hey, this one from Felix in the house. What's up, Felix? Thank you for this very nice dono from Felix. Says, USA Kurt, socialist admin's policies are violating Creator's immutable law. From Hebrews 10, we know him who said, vengeance is mine, I will repay. The Lord will judge. It is a fearful thing to fall into the hands of the living God. From Felix, the USA's socialist administration's policies are violating God's laws. I agree with that. I absolutely agree with that. I think that, humanity has, natural characteristics that are God-given rights, immutable rights. I think free speech is one of those. And when the administration gags you, when they take that away from you, when they censor you and silence you, they are operating adverse to the universe, or whatever you want to say, God's will, to the natural order of life. Right? Humanity thrives when it can be lit, when we can light up. And part of the way that we exercise our humanity is with our thinking and our speech. And so when they limit that and they call it disinformation, it's someone else trying to take your power away from you, trying to take your literal words away from you, and they get words, but you don't. They are extracting energy and extracting power away from your existence as a human being. And it's reprehensible that they do that. So I agree. They are trying to fight back against the natural God-given rights that we have. And that's why there's no alternative. Okay, we're not giving this up. We are not going the opposite direction. It's not going to happen. We've got a great one we got some from BitTorn. Dolphin fan is the man. We got those membos, Just Dia, Steve L, Danny M, Trisha B, and Southern Comfort all coming in courtesy of Dolphin fan is the man. We've got this one from Oil Smoke Jones. Says other leftist election interference trials, the judge just declared the defendant guilty. So maybe Chutkan can do that. And we got that one. Spud says Jack the Deranger. And Glocky McGlockface is over on Local. Says, Rob, Trump isn't just a former president or someone running for president. He is, by all accounts, at this time in his life, a private citizen until he is sworn in. And when you realize that the whole government is turned all its weapons against one U.S. citizen to try and bankrupt him and put him in prison, it should wake a lot of people the heck up. Even the British soldiers that were tried for the Boston Massacre got a fairer shake than Trump is getting. Yeah, I think you're probably right about that. Didn't John Adams even represent those people before he was president? So it's like incredible, right? But now your political opponents are just persona non grata. And it's a great point, Glocky. He doesn't have the full power of the presidency behind him now. It's just Trump. He's just running. He's got the power of the American people behind him, which is extremely powerful. But they're trying to deviate that, right? They're trying to shake that support loose by labeling him a criminal and an insurrectionist and all the things that nobody believes about. So it's an important thing that we hold the line on this, right? And that's why I think it's every time that they hit him harder, it just kind of solidifies the resolve that's out there, because it is not appropriate in our government to have that. We got, Zach Nichols is the man, absolutely clutch, bringing in the newest membos. Man, thank you for screen grabbing these, Zach. Outstanding, amazing. And thank you to Saint Chef. Saint Chef, we want to bring in all the latest membos, courtesy of your generosity. Let's do it. Who's coming in? Courtesy of Saint Chef. We got Deb H, Kathy R, Michael R, Angelia G. We got Celsify. Akbar is joining us. Will Call Magic. Marion's here. Another one is here. Calbo, James M, Winter, Debbie W, Philip H, Thos A. Big Boy Blues joining us. Rooted's here. Drea D, Mr. Otter Pockets. What's up? ASD's in the house. Douglas D, Peter J, Kendall K, G-Men. Tupac Shakur is here. Oh my gosh. West Side for life. We've got some more here. We got Joseph P, Cameron's here. Carl W, Tsunami Tommy's coming in. LES, Greg V, Old Chief, Purple Orchids here. Renee C, Thomas C, Adina J, Loki's joining us. Drive for Life, Tex Zombie, Gen X Boomers here. We got Ricky G, Gideon K is here. Made Ghost, Steve G, Scott L, Chris C, RKA, Pyramid 7, and Carrie, along with Drive for Your Life, all in the house, courtesy of Saint Chef, bringing in 50 membos. Saint Chef, thank you for doing that. Welcome aboard, 50 newest membos. And so hopefully we see you in the after party. Hopefully we see you on the members only stream tomorrow morning. Saint Chef, thanks for doing that. And Zach, thank you for clipping all of that. I tried to capture all of it and I missed it. So without you, we wouldn't have been able to give these warm welcomes. So thanks for doing that. We got Rose for Life on Locals, says they have to have the citizenry scared, war or pandemic, in order to control us. Right, because if we're not scared, if we're not distracted by endless war or endless death, no matter what it looks like, then we might hold people accountable or distract you with, the sports ball games or whatever else, is mostly non-meaningful, in my opinion. So that's from Rose. NY says, interesting to note, Jack Smith answered the amicus when he was not obligated to do so. He said that it was not brought up by Trump earlier, therefore not reviewable by the higher courts. However, Smith did actually cite his authority in his unnecessarily wordy speaking indictment, where Trump's lawyer challenged subject matter jurisdiction and his Smith's jurisdiction. Yeah, and I think, NY, you're referencing the most recent filing from Jack Smith before the case was rejected from the Supreme Court. He briefly touched on the amicus and he said, well, Trump's not raising this issue, so we don't need to address it here. Pinochet's bringing in those acronyms. I still don't know what those are, but I got to look those up. This old guy says, all this lawfare is wearing me out. It's exhausting, but I still think in the end we will prevail. We have to remain positive, and we have to work to elect Trump, impeach Biden, and hold the ultra lefties accountable. Man, that you're right, this old guy. We are going to prevail. We are going to win. The lawfare is a little exhausting, no doubt about it, but it's okay. We only have 12 more months of it. Okay. Well, that's not true, because after the election, there's going to be a bunch of litigation one way or the other. So we just got like 24 months left. That's not a big deal. So we'll just get through it together. This old guy, we're going to have some fun as we do, but we are going to need to stay positive and stay engaged. And I know that a lot of this stuff can be deflating, but we're going to do our best to hold attention, have some energy here, have some fun, keep coming back, because we need to stay engaged, right? I think a lot of the strategy here is to dissuade you. Just go, just watch something that's more entertaining and less lighthearted. But part of our goal is to engage people in this process so that when it's time to pull the lever, man, we got energy. We've got enthusiasm. We're armed with the facts, the knowledge, the law, and we've built a great community of people who support each other, and that's going to cause real change. And so we're going to keep holding attention on that. This old guy. Thanks for saying that, man. Thanks for the nice dono. We will prevail. Husky Mom is here. Says, Husky Dad and I would like to share our great news with the Watcher family. In September, we'll be welcoming grandbaby number 10 to the pack. Oh my goodness. Number 10. Woo! Welcome aboard. You're going to have a Husky pup, another one, in the Husky fam. And so that is awesome. Congratulations to you guys. Thank you for sharing that with us. Very, very cool. And what day in September? That's the other question. Oh, we might have an interesting birthday alignment there. But congratulations to you guys. Husky Dad, Husky Mom, and grandbaby number 10 coming in hot. We got Knox Bierman here on Locals. Says, we often use third-party defense, and how can a J6 trial not discuss J6? Well, it's a good question, Knox. I don't know. Hopefully you can answer it. Says, it would be akin to me trying to defend a robbery and murder client and not being able to discuss the robbery. Yeah, it's kind of weird. It's kind of weird. Or being able to discuss a DUI, but not really talk about the blood. I'm like, Well, I think your crime lab technicians are idiots. And they said, well, you can't talk about that. Well, why not? It's because it's going to wreck our case. Oh, well, that's not a good reason. According to Judge Chutkan, it might be. And Pinochet says NSPD 51 and HSPD 20, they abolished the Constitution. Well, that doesn't sound good at all. A lot of efforts have been in place to try to do that for quite some time, but that does not sound good. All right. So Pinochet, thanks for the update on that. Knox, thank you for that. And Saint Chef, thank you for the 50 membos. Dolphin Fan for the amazing membos. Let's say hello to our friends on X before we head on over to Locals, watchingthewatchers.locals.com for our members only after party to see what's happening over there. Who's joining us on the X platform? Oh my goodness, we got 32 membos. We got 32 viewers over on X saying hello. Very nice to see everybody. Let's see who's joining us in the comments section down here. And I always encourage everybody to follow each other on X and like each other's stuff and retweet each other's stuff. Danny says, when will they learn? Fred says the fact that Jack Smith and Chutkan were picked specifically for their Trump bias should not be allowed. Chutkan was picked for this trial. We got Howler dudes here. We got Misty's here. Says they're terrified of the truth. Darkside says, how can Citizen Jack say Trump's claims aren't factual if the so-called fact finders haven't even gotten to hear it and decide whether it is or isn't yet? It's a great question. Yeah, so they're not factual according to Jack, and he doesn't want to have many trials on it, right? He doesn't want to get involved and into the weeds on this, which is why he would rather have Chutkan just throw it out before trial even starts. What's up, Irene? Thank you for saying that. Thanks for being here. Thanks for watching the show. Very nice, lovely comment. George says, we've been having all kinds of technical difficulties in Hawaii too. I wonder if this is a prelude to a cyber attack. Oh, okay, I'm coming in late. Rumble still says upcoming. The stream is not live. Oh, did it actually? Okay, so okay. So it finally registered it. I'm frustrated. All right. Well, we're going to get it back up. Yeah, it's a little frustrating. So obviously that didn't get connected. So, all right, anyways, thank you for the update. So Pink Husky says, so Jack Smith finds that the defense is prejudicial against his case, while all defense evidence is prejudicial against the prosecution, as it is to debunk the prosecution's evidence and arguments. Hey, forgot my name, says great show. Thank you for that. Aubrey says, why isn't it working on Rumble? It wasn't scheduled. I scheduled it, but it wasn't connecting. Like it literally. So on my other computer, I pressed submit on separate tabs. It probably finally just went through, but I was waiting for it to schedule for about 35 minutes. Anyways, Warrior says, so to summarize, Smith is asking the judge to not allow the defendants to defend himself. Got it, Jack. And so great comments. This one from Feline says, I'm of the opinion that Jack Smith should be sanctioned. How long does Chutkan have to respond to the other two motions to dismiss? Can she just not respond to them and continue with the trial? No, Feline, right now, everything's on stay right now. So Chutkan really doesn't even have jurisdiction over the case. It's at the Court of Appeals. So it's going to have to go to the Court of Appeals, get decided before it comes back to her courtroom, and then we'll get some updates there. So my friends, thanks for following us over on the X platform at Rob Govea ESQ. Very nice to see you over there. We also have great other watcher members out there. And so we encourage you to follow other watchers out there, retweet each other's stuff, like each other's stuff, so that we can spread the good word. But that is it for us on the day. We are going over to watchingthewatchers.locals.com to hang out and debrief a little bit. But before we get over there, I want to thank the mods and the meme smiths who mod down the fort for us. Ultra shout outs to our friends Zach Nickel and John Allen who modded down the fort for us today. Thank you, John and Zach. I know it was a busy one. We got Janek also here. Dog Digger. We got Beyond Geo. Zulu. We got Ronnie Cole. Playing hooky, Just Cause, of course, K-Bean in the house, always helping, and Vienti Kiss, I think's on vacation, enjoying the holiday break or something. Hopefully he's having a great time. But we miss you, V. Hopefully you're having a fun time, my friends. We also want to thank our meme smiths, Geegum Geegum, Twitter, Sleepy Dog Lee, and our friend Nathan N810 in the house. But that is going to be it for us. We are going over to watchingthewatchers.locals.com for our members only after party. We would love to see you there and on our morning stream. But if not, well, we are going to be back here tomorrow to get into it all again. And we hope to see you right back here so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with a hope of finding justice. Make it a beautiful night, my friends. Sleep very well. We'll see you right back here tomorrow. Bye-bye.